Oh yeah, I have this link. Soon 219. I had this link on tab. I should show this one.
This is where pride is excessive. Gay pride is excessive when you see it on a church. Now, I don't understand this. Quite frankly, to me, it feels like they're excluding me. You know, we're all sinners, yet you don't bring that stuff to, you bring yourself. Look, I don't know how to put it. I just feel that this is wrong, okay? This is exclusionary. That's what it's starting to feel like. Excluding folks who are not gay when you celebrate it this much. And by the way, they were doing this way before Pride Month. This is where pride is.
You know, you could have made a good point about how these corporations will not defend you and are only doing this. They're just taking on the banner of social justice so that they can improve their personal image. They don't really care about it and they're not trying to advocate it. And instead, he tries to say that he's going to dictate what a church can believe. Also, if you haven't seen a pride flag on a church, like, have you never seen a church before? I mean, they're all over the place. Remember when Greg Kelly's NYPD head of police father obstructed that rape case about him? I mean, is that true? Jesus Christ, I didn't even know that. All right, hold on. Let's watch this one, and then we'll watch How to Buy a Gun in Canada. Uvalde and police duty.
In Uvalde, Texas. I'm not going to go into detail, and new facts are coming to light every single day. But one thing it seems is certain is that the police, to put it charitably, did not act in a way that most people wanted them to act. By all accounts, there was a very long delay between the time that the police arrived on scene and when they took action to stop the shooter. So, people angry at the tragedy are asking, can the police be held legally responsible, not for their action, but for their inaction? And I'm not going to hide the ball on this one. The answer is almost certainly no. But the reason why might surprise you, because most people believe that the police have a legal duty to help. And unfortunately, according to the Supreme Court, that is not the case. While their motto may be to protect and serve, the police have absolutely no duty whatsoever.
What? By the way, chat, this is totally incoherent. Why do we have a paid gang roaming the streets? The idea that they don't have a duty to protect is lawyer-brained bullshit, and it's insane, and we ought to create that duty. I don't give a shit what the Supreme Court says. Fuck you. This is nuts.
To help anyone that's in trouble. Now, normally this would be the part of the video where I run through the factual summary that gives rise to all of the legal issues. I'm not going to do that today because honestly, it's just too hard. But these are important legal issues, and this is one of those videos where it's not about what the law should be, it's about what the law is. Now, we've talked a lot on this channel about the difficulty in suing police for the things that they do, the mistakes they might have made. Qualified immunity generally protects police officers unless it was clearly established that what they did was unconstitutional. There are all kinds of controversies in this doctrine. This is not the video for those particular questions. But the question presented by the Uvalde shooting is different. Here we're asking whether government officials can be sued for actions they did not take. Now, the Supreme Court has ruled twice that government actors like police and social workers actually have no duty to protect anyone.
Now, you know this, chat, because we've talked about this issue like 10 fucking times on this stream. But let's go through, Legal Eagle's view of it. I want to see his the way he describes it.
Precedent was established in 1989 when the Supreme Court decided the case of DeShaney versus Winnebago County Department of Social Services.
And what happened? The cops didn't care when a mom went to them and said, my kids have been kidnapped by their father, by my ex-husband. They did fucking fuck all. And then the guy murdered the kids.
In that case, in 1982, Joshua DeShaney was a 4-year-old boy living with his father, Randy, in Wisconsin. Randy had primary custody of the child and had recently gone through a second divorce. Joshua's stepmother told the Winnebago County Department of Social Services that Randy abused his son.
Oh, wait, this is the different case. Sorry, Chad. This is a different case. That's the second case he'll probably get to.
Randy denied it, and the county took no action to remove the child. However, in 1983, Joshua was seen at the ER for bruises. The ER doctor notified social services, and Joshua was removed from Randy's custody for a few days. Randy wasn't charged, and the child was returned to his custody. A social worker was assigned to visit the home. And in 1984, the social worker visited the house 20 times, noting that the child had bumps, bruises, and injuries on his head. The social worker also documented that Randy failed to attend his regular counseling sessions or enroll Joshua in preschool. And during this time, Joshua ended up in the ER twice with suspicious injuries. The social worker said that she feared for his life but took no action to remove him from the home. And unfortunately, in March of 1984, one day after the social worker's visit, Randy beat Joshua so hard that he fell into a coma. Joshua had severe brain damage and was permanently paralyzed. The state then placed Joshua in an institution where he would remain for the rest of his life. Joshua DeShaney's mother sued the Winnebago County Department of Social Services, alleging that the department had deprived Joshua of his liberty, interest in bodily integrity, in violation of his rights under the substantive component of the 14th Amendment's Due Process Clause, by failing to intervene to protect him against his father's violence. Now, the Due Process Clause of the 14th Amendment declares that no state shall deprive any person of life, liberty, or property without due process of law. DeShaney argued that the county had a responsibility to protect Joshua because it knew Randy abused him. The social worker had tracked the abuse on paper for over a year. DeShaney argued that through the social worker's visits, the state had established a special relationship with Joshua that created a responsibility to protect him from known dangers. Then Chief Justice of the Supreme Court, William Rehnquist, wrote the majority opinion, which found that the Due Process Clause only applies to states, not to private citizens. Since Randy was the one who beat his son, the court reasoned that the state didn't directly cause Joshua's injuries. And the majority also rejected the argument that...
So, in other words, even if the outcome was highly probable and known to the state, it's not the state's action if a third party does it. That is fucking insane.
That the state made Joshua more vulnerable. The purpose of the Due Process Clause, quote, was to protect people from the state, not to ensure that the state protected them from each other. The court held that the 14th Amendment did not grant any citizen a guarantee of, quote, minimal levels of safety and security. The
14th Amendment doesn't guarantee that you have a right to security. The Constitution doesn't guarantee you have the right to security It does say you have the right to have a gun, but God forbid you say you have the right to security. No. We spend $815 billion on the military because we don't think it's a right. Insane logic. Brain dead conservative legal logic. This is what conservatives do. Incredible.
The court also said that people have no right to governmental aid. The court held that the due process...
And that's what the conservatives wanted to say. You have no right to government aid. That's it. That's the conservatives why they came out on this case. Because they wanted to make it that you couldn't make a constitutional argument that the government has to protect the general welfare, which is one of its motivating reasons of existing. They wanted to go against the plain text of the Constitution, which says, we, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution of the United States of America, for the United States, rather. They say that the government doesn't have an obligation to do what the government says it set out to do. That is fucking batshit. We don't have to ensure your domestic tranquility or common defense. What? That's the reason it says it in the Constitution's preamble. That is the batshit crazy because why? Conservatives have an ideological opposition to the state being responsible for you. So they ignore what the Constitution says in its plain language in order to take away benefits. Because God forbid, chat, imagine if the state had to care for 4-year-olds who are getting beat by their parents and abused. Imagine the burden that would put on our government. Oh no! That is the conservative mentality. Fucking batshit crazy.
This clause would only apply if the state had assumed custody of a person against their will and then failed to provide for their safety and general well-being.
It's a 4-year-old. They don't have a will. It's a 4-year-old.
Justice Brennan and the 2 other dissenters saw it another way. They believed that since the state had acted through the social work department, they assumed the responsibility for the child's safety. The dissenters said that if the state had never intervened, then others in Joshua's life, like his mother, might have taken other actions to get him away from Randy. And basically, in the DeShaney case, what happens is that a mother is worried that her son, who's in the custody of the father, is being abused by the father. She goes to the police. They send social workers out. A social worker visits 20 times, sees lots and lots of evidence of abuse. Ultimately, the social services doesn't do enough, and the child is horribly and permanently injured by the father, in large part because social services allowed the child to remain with the husband. Now,
that is everybody with a brain's take. There is no alternative take. If you have a functioning soul and brain, that's the take. The government failed in their duty to protect a child. That's the only take. Any other take is fucking morally depraved. And you're not wrong for thinking so. 3 Supreme Court judges agreed with you. That's not some sort of out of left field crazy Libby take, left wing crazy take. You got 3 people on the U.S. Supreme Court that agreed with you. The 6 that didn't are fucking evil and batshit crazy. And they're wrong. They're wrong morally, they're wrong legally, they're wrong from a basic smell test. And you're not wrong for thinking so. You are, in fact, sane. It is an insane decision.
Obvious differences between what happened in Uvalde and a social worker who fails to remove a child from a violent parent. But that takes us to the 2005 case of the town of Castle Rock, Colorado.
This is the one I'm talking about, where the mom went to the police and they were just didn't listen. So I went to a playoff game, and of course, fights broke out after the Oilers lost. My dad was screaming for the cops to come help this brawl as people were getting their heads smashed into concrete, and I yelled at the cop to do something and call for backup. And then the other cop casually walked through the fight, and I yelled at him to hurry up and do his fucking job. Fuck, I hate pick. What, you think the cops want to intervene and protect someone? Are you crazy? They're taught that their number one goal is to go home at the end of the shift. They're not taught that they're there to serve the general welfare or preserve peace. They're there to suck money and then go home and retire at 50.
Versus Gonzalez, where the Supreme Court applied the same rationale to a case involving the police. Now, in that case, Jessica Gonzalez had asked for a restraining order against her estranged husband. There was a Colorado law that made domestic violence restraining orders mandatory whenever one party felt threatened. And the state trial court issued an order prohibiting the husband from seeing Miss Gonzalez or their 3 daughters unless it was through a pre-arranged visit. Now, just 1 month later, the husband kidnapped the 3 children. Miss Gonzalez had direct evidence that he had the kids because he confirmed it on the phone. She begged the police to search for her husband right away since he violated the court order. Now, the Castle Rock Police Department told Miss Gonzalez that it could do nothing and told her she had to wait until 10 p.m. to see.
So in other words, she had a restraining order. She got it confirmed on the phone that the husband had stolen the kids, and the cops said, we're not going to do anything.
If her husband brought the daughters home. At 10 p.m., the police told Jessica to wait until midnight. At midnight, she went to the police station to beg them to arrest her husband. An officer took the report and then went to dinner. A few hours later, Gonzalez's husband went to the police station and opened fire. Police killed him in the melee. And when they searched his truck, they found the 3 girls dead in the back. Gonzalez's husband had murdered all 3 that night. Miss Gonzalez sued the Castle Rock Police Department for violating her due process rights. And the 10th Circuit Court of Appeals found that she had a, quote, protected property interest in the enforcement of the terms of her restraining order, which the police had violated. But the Supreme Court reversed that decision, ruling that Gonzalez had no constitutionally protected property interest in the enforcement of the restraining order, and therefore could not claim that the police had violated her right to due process. Justice Antonin Scalia wrote the majority opinion. He reasoned that the state law didn't entitle anyone to mandatory action by police, even though the issuance of the restraining order was mandatory under Colorado law. Restraining orders provide the grounds for arresting a person constrained to the order, but that doesn't mean that the recipient can force the police to act. Scalia wrote that under the Colorado law, police have discretion to decide whether to enforce an order, and if so, how they would do so. The court concluded that, quote, since Colorado had not created such an entitlement to mandatory action, Gonzalez had no property interest and the due process clause was therefore inapplicable. The court ultimately concluded that unless a legislature specifically said, we're creating this right and if we breach it, the private citizen can then sue the government, then the citizen is out of luck. And as one court put it, quote, law enforcement officers often consider themselves responsible for protecting the public and deterring criminal activity. However, the legal doctrine that specifies the legal duty of law enforcement officers holds that they have a duty to the public, but not to individual citizens. This is what's known as
no duty. Because if you have a duty to the public, but not people, the public doesn't exist. It's a fiction. It can only be expressed through actions up to individual citizens. It's fucking ridiculous decision, absurd decision.
a public duty doctrine. The doctrine means that the officers don't have a duty to protect citizens from harm by a third party. In other words, there is no clear duty to protect individual citizens. Now, that being said, the DeShaney decision recognized two possible exceptions to the general rule that the state has no duty to protect people from harm. The first is what's called the special relationship exception, which holds that the Constitution imposes upon the state a duty of care towards individuals who are in its custody. As is usually summarized, quote, when the state takes a person into its custody and holds him there against his will, the Constitution imposes upon it a corresponding duty to assume some responsibility for his safety and well-being. So when the state has a special relationship with someone, there may be a duty to protect. If this relationship exists, the state official must take reasonable steps to ensure the safety and care of that person and to safeguard them against foreseeable risks. However, most courts say that the only time the state forms a special relationship is through incarceration, institutionalization, or other similar restraint of personal liberty. And most courts reject the theory that people waiting to be rescued are in police custody and control. This is particularly true in the Fifth Circuit, and perhaps the most analogous Fifth Circuit case is Salas versus Carpenter, where a county clerk was taken hostage at the courthouse by her abusive boyfriend. And during the hostage negotiation, the sheriff ordered that the city SWAT and hostage negotiation teams leave the courthouse. He then replaced them with county personnel not trained for SWAT or hostage negotiations. The man killed the county clerk, and the Fifth Circuit sided with the sheriff, finding that he did not violate her constitutional rights by using untrained negotiators. The court said, quote, generally the absence of a special relationship defeats any due process claim based on a failure to provide protective services. The victim was not held in state custody or otherwise prevented by the state from caring for herself. This was a failed rescue effort. And it's easy to see how the Fifth Circuit, which covers Texas, would probably make the same call in the hypothetical Uvalde case. The police were doing something. They were securing the parking lot and stopping parents from getting inside where they might get hurt. And just because the effort failed, and failed badly, probably wouldn't change the Fifth Circuit's analysis. But under the DeShaney case, there is a second exception, and that is called the state-created danger exception. And under that theory, some courts have recognized that state officials have a duty to protect individuals from harm when their actions created or exacerbated a danger to that individual.
Now, for me, as a radical socialist, I would say that the state created the entire situation by allowing an 18-year-old to buy an AR-15, and then secondly, exacerbated that harm by preventing parents from intervening, by doing nothing for well over an hour and sitting on their fucking fat asses while children bled to death. They stopped the community from doing self-help by preserving the situation that led to the deaths of those children. And the state created the environment that allowed that 18-year-old to have the weapon in the first fucking place. But of course, the Supreme Court, the courts would never agree to such a doctrine because they mean specific actions in the specific circumstance, not the general policies of the government.
But here it seems like this exception wouldn't apply. The police didn't help, at least not in the way that most people wanted them to help. But at the same time, they also did not create the situation itself. Now, those of you that have been paying attention might have come up with a legal theory that might differentiate what happened in Uvalde, Texas from the prior precedent. And that is that children are mandated to go to school. Often, those schools are provided by the government. And in this case...
Great point. All those children were forced to go to school. All those children, they had school resource officers, which implies that the police have a duty to protect the children at school. They failed utterly in their duty. This is a great argument, actually. Good job.
This massacre occurred at a public school. So aren't the children within the custody of the government? And doesn't the government...
And in fact, schools have in loco parentis over students that are within school district times. Oftentimes they act in place of parents to make decisions about discipline, about, where the children go within the school, where they have to, what classes they attend, where they physically, how they are transported, who watches over them. Absolutely.
Then have an obligation to provide for the health and safety of the children, especially a school that has a police officer and a school district that has its own police department. Well, it's complicated, but it probably doesn't turn out the way that you might want. Because unfortunately, this is not the first time there has been a massacre on school campus. And a relatively recent case is almost directly on subject. and that is the case arising out of the Parkland situation. In late 2020, the 11th Circuit Court of Appeals cited the Castle Rock and DeShaney cases and dismissed a lawsuit brought by the victims of the Parkland, Florida shooting at the Marjorie Stoneman Douglas High School. Now, there, the students alleged that the county sheriff and deputies incompetently responded to an active shooter situation, violating their due process rights. The deputies knew that the shooter was a danger to the community, and school officials had also known that the shooter was deeply troubled and had made threats. The plaintiffs alleged that the deputies had failed to intervene during the shooting, and they also noted that one deputy prevented EMS from providing life-saving care and blocking them from entering the school during the shooting. The 11th Circuit Court of Appeals, which is one step below the Supreme Court, found that a plaintiff could only allege a substantive due process claim in two situations. First, when the person was in the government's custody, and second, when government officials' conduct is arbitrary or shocks the conscience. Now, first,
My conscience is pretty shocked.
Held that the children were not in police custody. And as far as shocking the conscience, the court held that in an active shooter situation, police have to make split-second decisions in the midst of chaos. In this situation, quote, an official's conduct will shock the conscience only when it stems from a, quote, purpose to cause harm. That means that a plaintiff can only sue if they can show that the government officer purposefully caused harm. If the police officer didn't intend to hurt anyone, then they can't be sued. And with respect to whether the children were in...
I'm sorry, but for me, if you sit there for an hour as children are calling you to save them from the shooter, you're intending to cause them harm if you do nothing. The kid Hasan had on his stream who was there during the Parkland shooting said the ISD officer that he saw almost every day ran away with him when the shooting started. That's why more police isn't the solution. Do you have a clip of that? Salty, give me that. Give me a clip
government
of that.
Custody, the court held, quote, it is well established that school children are not in a custodial relationship with the state. A custodial relationship exists only if the government places limitations upon individuals' ability to act on his own behalf that are similar in kind to incarceration or other forms of involuntary confinement. School attendance, even when compelled by truancy and compulsory attendance laws, is not similar in kind to incarceration or institutional confinement. Ordinarily, there are no custodial relationships in the public school system, even if officials are aware of potential dangers or have expressed an intent to provide aid on school grounds. And in the Parkland case, the biggest controversy was about Scot Peterson, a Broward County Sheriff's deputy and school resource officer. Peterson stayed outside of a school building for over 40 minutes as students and faculty members were gunned down. And the state of Florida charged Peterson with neglect under a statute that applies to caregivers. Now, this is generally a novel interpretation of the law, which usually applies to parents or adult household members or teachers. Now, Peterson will stand trial on this criminal case. But the 11th Circuit dismissed the civil case against Peterson for the same reasons it dismissed the cases against other defendants. That the students were not in a custodial relationship with the officials, even the school's armed resource officer. A lot of people disagree with this particular ruling, and it can be solved with legislation. But as it currently stands, there is no inherent cause of action based on the Constitution that would allow
two different
parents and teachers and victims to sue the police for inaction at
disabled
Uvalde.
people.
And unfortunately, that is the current state of the law.
In Parkland, the SRO, the school resource officer, who I saw every single day at school, like he was doing the traffic entering, like we all knew this guy, Officer Scot Peterson. He fucking Irish exited the shooting, saw that there was a mass shooting going on, and dipped out literally faster than I've ever seen anybody leave anything. And then instantly, like conservatives were like, all right, well, we need to get as many cops on campus as possible. And that's where the within the left wing kind of discussion about guns gets complicated is, okay, disarming members of the working class is dangerous in a country where the working class is actively oppressed. But on the other hand, disarming the working class is like, putting police officers in these situations only makes them more violent. And with the AR-15s and similar guns, there's already so fucking many of them out there. An assault weapons ban is about stopping those things from entering the market. It's not about anything else. There's too many for it to be safe for consumer use, and they're marketed like consumer products. They have the same fucking focus groups doing their advertisements as there are for Mattel. Like, it's insane what's going on. And within the left, it's difficult because people make really good points about police being brought into situations when other people.
Okay, let me just say this. That was really what I wanted from that was him talking about the cop running away and not hiding. The idea that there's some sort of robust self-defense of the class conscious and organized working class is fucking babble and quite frankly a waste of everybody's time. We don't even have a workers' party, let alone paramilitaries. Okay? Please stop. We don't have our proletariat is not going, ooh, I need to organize in a class-conscious militia to defend the interests of our class against the bourgeoisie. That's not happening. So you're talking about a hypothetical world that does not exist. And even if it did, civilian regulation of firearms is not going to deter that. Oh, we are class conscious. We are proletariat. We do want to form ourselves a self-defense force, but there's some regulations on ARs. I guess we give up now. What? It's not complicated, actually. I just want to live in a normal society for the time being, and when the revolution kicks off, we'll get our guns. Don't worry. Bad Empanada had the best take. The proletariat must, under no circumstances, give up their arms. The only exception to this is the American proletariat, which will do nothing revolutionary anyway and only uses guns to do mass shootings. They should have gun control. Are you watching the stream unsubbed? You're making income inequality worse. You are doing anti-praxis. We are the only Twitch stream that will not accept scam advertisers, and I will never fuck you over by selling you crap.